My stomach sank. I was appalled. I felt like I'd been catapulted back into the 60s.
That was the reaction of Randall County Democratic Chair Jan Allen as she learned of the 5-4 ruling by the Supreme Court.
What the Supreme Court found, or what Chief Justice Roberts found, was a problem was that the method for determining what states were covered by preclearance was based on data from 1964.
With the removal of Section 4 from the 1965 Voting Rights Act, states no longer need clearance before changing election laws and are allowed to move polling places as they see fit. The act was put into place to prevent voting discrimination, and without Section 4, many wonder what is next to come.
Section 2 is still in effect. And under Section 2, if you think that that's a discriminatory action, you or the federal government could come in and sue the city, the county, whatever jurisdiction is the one that moved the polling place.
But not everyone is convinced that even the other sections of the act are safe.
I just have to say that I'm disheartened in the Supreme Court decision. I really did not expect this, and I'm brokenhearted that it occurred, because it sets a precedent for possible chipping away at the other sections, and people's lives were given for that.
And as a domino effect of the ruling, Texas wasted no time in implementing the voter ID law, requiring all voters to show photo ID at polling places.
Texas voter ID law was tied up in preclearance. So the U.S. Attorney General and the Department of Justice said that you cannot actually implement this law until we pre-clear it, to make sure it's not discriminatory.
Whoever comes out in the end ought to stand for the people, not for their own personal platform.
Chanel Douglas, Pro News 7.